Special Counsel Jack Smith has just filed a notice of appeal to the 11th Circuit Court of Appeals in the Mar-A-Lago document case, appealing the order by Judge Aileen Cannon, where she dismissed the Mar-a-Lago document case against Donald Trump, where it was alleged that he stole nuclear codes and war plans, and where there were photographs and surveillance tapes of his valet Waltine Nauta taking boxes and moving them around to obstruct justice. The case was dismissed by Judge Aileen Cannon under the grounds that she said the appointment of Special Counsel Jack Smith violated the appointment clause of the United States Constitution. She said that he was an inferior officer, but that his roles and responsibilities made him someone who should have required a confirmation and appointment process appointed by the president and confirmed by the Senate. And since that wasn't happened, she said that the entire case against Donald Trump should be dismissed. Now, for decades, there was clear precedent that special counsels were valid, that there was no appointment clause violation. Various departments of justice in both Democratic and Republican administrations have used special counsels historically. In the case of United States v. Nixon, the Supreme Court previously held that special counsels are fine. The issue about special counsels being unlawfully appointed had previously been brought before many other courts who just rejected the argument as out of hand, didn't even hold hearings about it because it was such a frivolous argument. But Judge Aileen Cannon held a full day hearing, multiple day hearing, where she actually invited amici, people who filed what's called an amicus brief or a friends of the court brief, who were supporters of Donald Trump. She turned her courtroom into a circus, allowed these right-wing groups, including one group backed by Citizens United, to show up there, make arguments that the special counsel violated the appointment clause, and then she basically copy and pasted their arguments, also with an assist from Justice Clarence Thomas in a concurrence that Justice Clarence Thomas, the corrupt Supreme Court judge who was bribed over $4 million by Trump backers like Harlan Crow, who has posters or photographs or paintings by Adolf Hitler in his office, which are probably also fakes, but he thought that they were real. I digress, but Justice Clarence Thomas, in his concurring opinion in the overall decision which granted Trump absolute immunity, he sent a message to Judge Aileen Cannon to essentially dismiss the Mar-a-Lago document case based on the fact that he believed the appointment of the special counsel violated the appointment clause of the Constitution. So Jack Smith went to the 11th Circuit right here. He will be he will be bringing that appeal. It's now formal. It is now official, folks. I was able, and I think he will also soon, although it's not in this motion, I believe he soon will be moving to remove Judge Aileen Cannon as well, and he will be making arguments like that. We'll bring you those arguments when I think that they will, and I do think they will be happening. I recently had a discussion with Harry Litman about this from the Talking Feds YouTube channel. Let me bring in Harry Litman and see what he has to say about Judge Cannon's decision. Let's watch this. I'm joined by Harry Litman of the Talking Feds YouTube channel and the Talking Feds podcast. Make sure you subscribe to both. Harry, Judge Aileen Cannon is done. I mean, she dismissed the special counsel's indictment of Donald Trump in the Mar-a-Lago document case. And I want to hear from you, though, now that she's made that order, though. I mean, it's 93 pages. It's again the Mar-a-Lago document case, 93 pages, but none of it bears any resemblance to like cogent or coherent legal analysis. It was just kind of rambling with, kind of just extreme like fantasy land, hypothetical stuff that she will be reversed, I think. The 11th Circuit will probably remove her from the case when they get it and when they get to it. But she kind of waited. Her timing was right now so that she can deliver to Donald Trump the final gift. I think wait to the Republican National Convention and then drop this bomb, keep it, she didn't even put in her order staying her decision. It just like dismissed, case closed. And I think she realizes that if this goes to the 11th Circuit, which it will, she'll likely be removed and overturned. But her final gamble is, I think Trump's going to win. I mean, that's her gamble. Trump will win. And if that happens, I'll get a Supreme Court job, or I'll be on the short list, and I'll definitely be in 11th Circuit because I betrayed the law and did what Donald Trump wanted me to do. I saw a New York, an NYU professor who was saying before, I wasn't really paying attention, but I heard all this extreme rhetoric criticizing Judge Cannon, so I was turned off by it. So I wasn't really paying attention to it, to which I responded, just telling you what she was doing. I mean, it wasn't extreme rhetoric. She was engaged in an extreme dereliction of duty. What do you make of this all?
It's just 100% true. It's embarrassing and shameful. And so these 93 pages of pseudo scholarship. First of all, she goes running with Justice Thomas's concurrence, and that's a sort of separate little scandal here. In the immunity case, he agrees completely with the majority, but then just says, I'd like to give a few thoughts, almost like parlor room discussion. He's not sure, he says, that in fact that the claim that she upheld is accurate, but she goes running with it. And I really got to say, your market paid in full now, because as you say, they right now are they've already decided to appeal to the 11th Circuit. And Ben, that's already kind of an important point, because some people are saying, all right, look, go running with what she said and now just refile right away, because it's not they're able to refile it. But the department doesn't want to do that, because Merrick Garland and the department are really committed to this principle of using special counsel in order to avoid any appearance of impartiality with prosecuting Donald Trump. So I think now the 11th Circuit, if they get it, they will reverse and very possibly bounce her. There's reason to think they want to do it, and that she has, they see her as an embarrassment. On the other hand, she's done the big gamble, and if Trump wins the election and first of all, the case is over, because he can simply tell the Department of Justice to stand down and forget about it. And then second, there's really no way to kind of take account of it in the election, which is what he's hoping. So, I wrote an op-ed on this. Maybe we should link it if you're able, but I started with the sort of conventional, this is wrong. Oh, she's saying this about Nixon. That's crazy, etc. But it's just not the way to go, because it just misses what, the hand in front of your face, which is she was in the tank. It's a hypothesis one comes to very slowly and methodically, but it's just the fact. She kind of put herself in from the very beginning with her patron. And I think of this as the very first opinion of Project 2025, in the sense that the rule of law takes a backseat to the preeminent principle of loyalty to Donald Trump. And this is that opinion par excellence. It really isn't even worth trying to trash in legal terms, because it's risible. It goes against everything, and especially for a district court judge. It's cheeky, it's lawless, and it won't stand, except the timing, may permit it to, if you have a Trump victory. And that's the play, that's the gamble it's now pretty clear she's made from day one. It's really shameful.
President Biden wins. This goes through the appeal process. Judge Cannon almost certainly gets removed from the case when you play it out. It'll go in front of a actual law and order judge. Maybe it goes in front of the presiding judge, Altanaga, who previously criticized Judge Cannon for not recusing herself and asked Judge Cannon to recuse herself. And by the way, federal judge Altanaga was an appointee of George W. Bush. So it's not like we're talking about this is like a conservative liberal thing. This is a law and order thing. And as you say, versus a Project 2025 judgeship thing. And when you think about it as well, you had, we talked about this on a prior hot take we did, in the absolute immunity decision that was made by the Supreme Court, you had a concurring opinion by Justice Clarence Thomas, who, even though the issue about the unlawful appointment of the special counsel was never even briefed or even before the court, you had Clarence Thomas write this bizarre concurrence. And justices are never supposed to write concurrence. I mean, you clerked for 2 separate Supreme Court justices. You don't write opinions on random things that aren't before you to give advisory guidance to others. That's just not, that goes against everything that the Supreme Court's supposed to do. But Clarence Thomas sent this message to Judge Cannon about what to do. And then in her order, she took the message from him and then basically copy and pasted it and cited him as one of her justifications, not the ruling of the court, the concurrence. How unheard of is that?
Yeah, I mean, all her authorities, Scalia's lone dissent in Morris and Thomas Lone, Judge Jones, who is really considered out there. It's as if she occupies a whole different, legal realm where these marginal folks who are just not, their views have not become law. Nevertheless, for her, they are law. It is, very unusual for sure, but I just want to emphasize it's not, it just doesn't, it's not made cogent by any kind of legal sound views or anything like that. It's as result oriented as it can be. In terms of your notion, Ben, that if Trump loses the election and the case remains, that the circuit court will bounce her. I think they will, and in any event, even if they don't, the department can now file in a different place. I do think we have seen the end of of Cannon on this case, but not before she's really done it right. There are opinion after issue that she decided not to actually determine, so that she couldn't be reversed. There are 9 pending cases, but this one she went, whole hog on, and that's, she's done her service. But I do think that she's rolled the dice in a big way, because a new judge really cares most about their standing with other judges on the court. And I think her standing has to be very poor now, but she's gambling with the sort of power move anyway, which obviously is something that Trump is, nothing's too crass for him to elevate her. And that's the kind of, hope she's got.
So for all of this talk by MAGA Republicans about the weaponization of the Justice Department, the judges Donald Trump appointed are letting him off the hook from his crimes. But Hunter Biden, President Biden's son, and Bob Menendez, a Democratic senator, are the ones who have been convicted and likely serving prison time as of now. So that's the status of it. And so
that's the irony. Yeah, and the problem there is it permits a sort of dialogue or talking point of, everybody does it. Menendez is going to get sentenced now a few days before the election, and you don't want to be crass in the wake of an assassination attempt, but it's just a fact that there's one side that is fanning the flames here, one side that is really bringing violence to bear, one side that is really threatening to undo the rule of law, and that's Trump if he's elected. So we can't forget that fact, and we have to do our best to sort of really bring it home, and so that people understand the stakes of the election. It's not like they both do it.
Harry Littman, Talking Feds YouTube. Make sure you hit subscribe on the Talking Feds YouTube channel. They're on their way to 300,000 subscribers. Let's get there.
Love this video? Make sure you stay up to date on the latest breaking news and all things Meidas by signing up to the MeidasTouch newsletter at MeidasTouch.com/newsletter.